Hi, thanks for using my court coach. I'm Sarah and I'll be your instructor as we talk about the judgment form, also known as form FL-250. This is the judgment form that you would use to either finalize a judgment in a case where you have petitioned the court to establish a parental relationship, or where you have petitioned the court to make custody and visitation orders and support orders where there is already an existing parental relationship established. As with all our court forms, you're going to fill in your identifying case caption information at the top. Below that, if there are restraining orders in effect, as part of this judgment, you want to mark box 1 that lets the court know that to look for the personal conduct restraining orders. Either this judgment contains personal conduct restraining orders or it modifies existing orders. If either of those are contained in the judgment, you want to list where in the attachment to the judgment the court can find that information. You want to list the expiration date for the restraining orders, and then you will also need to attach a CLETS form to this attachment. A CLETS form is a confidential form that gets entered into the sheriff's system that lets them know there's a restraining order in effect. If there are no restraining orders, don't worry about filling in box number 1, just move on to box number 2. Box number 2 is where you indicate if this is an agreement that's being submitted as a contested matter or an uncontested matter. If it's uncontested, in other words, there's a written agreement, or if it's by way of default, you would mark the box that indicates that. Don't worry about the box that says by declaration. We almost never use that. If it was a contested matter, in other words, there was a trial, then you would mark the box that says contested and then list the date, department, and name of the judicial officer who heard the matter. And if that judicial officer is different than the one that's normally assigned to the case, then it was temporary judge, mark the box that says temporary judge. Below that, you want to identify the parties that were present, and if they had attorneys present, then you want to fill in the blanks that have where you would write in their name. The next set is going to be a little confusing because, as I said, this form can be used to either establish a parental relationship or just order custody and support orders where a parental relationship has already been established. So, and I'm going to go through just the set for petitioner. The same applies to respondent, but if this was a trial matter, then you would want to indicate that the petitioner appeared without counsel and was advised of relevant rights. If this is a establishment of paternity case, then you would want to mark box 2F2 that indicates the petitioner signed the advisement and waiver of rights regarding determination of parental relationship. That is a mandatory form before the court can find that paternity has been established. If this is a child support custody case, then you could mark, if it's true, that the petitioner is married to the respondent and there's no other action pending. If this is a establishment of paternity case again, and if the petitioner signed a voluntary declaration of parentage or paternity, you can mark box 2F4. If this is, again, a case where paternity has already been established in a separate case and you've just filed a motion to make custody and support orders, you can mark 2F5, and that just tells the court that paternity has already been established, so that way they're not looking for that FL-235 form. So same boxes for respondent, just go through and mark what is applicable. Again, if this was a trial setting, if there were any other parties or attorneys present, you would specify that under 2H. And then finally, below is the finding of paternity, if a finding has been made. And again, that's only if this is an establishment of paternity case. You would list the names of the parties that are the parents of the children, and then the children's names and birth dates below. If this court has made custody visitation orders, and you're including that as part of your proposed judgment, mark box 4A, and then indicate in what format those custody visitation orders are being provided to the court. It can be either one of these forms, the child custody and visitation order attachment. And if you had a trial, you could fill that form out, which would indicate what orders the trial made. It could be a stipulation and order for custody and or visitation of the children. If this is an uncontested case and the parties have reached an agreement, you could use this form, the FL-355. Or other, if you've just written out what the orders are, whether that be a written agreement or just a synopsis of what the court ordered, you can attach that to this form and just say other, see attachment to judgment. Same goes with child support below. If there are child support orders made through this case, mark box 5A. And again, You can use either of these forms to indicate what those orders are, or if you have a written attachment, that's fine too. You can mark box 3 and just specify that there's a written attachment. If there are child support orders being made via this case, then each party needs to fill out a child support case registry form that's an FL-191 within 10 days of the date of this judgment. And there also should be a notice of rights and responsibilities attached to this judgment. That is the FL-192. If this judgment contains orders changing the names of the children, you would want to mark box 5D and indicate what the name change is. And if there is an order that names are to be changed and the birth certificates are to be amended to conform to that order, mark box 5E and indicate specifically, is the parent's name supposed to be added to the birth certificate, or are the last names of the children supposed to be changed on the birth certificate? If either of those orders are made, mark the box that reflects that. If there has been an order regarding attorney fees, mark box F. If there has been an order that one of the parties pay or contribute to the expenses of pregnancy and birth, it's stated in the attachment to the proposed judgment, then mark box G. And if there are any other orders pertaining to either the establishment of paternity, if this is a parental case, or child custody and support, in either case, then you would want to specify that here. If this is not enough space, you always have the option to attach another page. If so, mark the box that says continued on attachment. We have obviously discussed a number of forms and pages that are supposed to be attached to this form, so tally those up, list the total number of pages attached below, fill in your name, fill in the judge's name at the bottom if you'd like, or just otherwise leave it blank just in case a different judge signs it. This is a form for the judge to sign, and once he signs it and sends it back, that becomes your official judgment of either establishment of a parental relationship or a judgment just for custody and support orders. I hope that you found this helpful. Good luck.